This one is Chapter 10, Protect Your Intellectual Properties with Patents. Let's read the quote. There is no business entity or individual that has it made. There is no business so successful and secure that there isn't the chance of a big surprise just around the corner. Success is a thing of the past, not the future, because you can never be sure what's coming. About all you can predict is that things will change and there will be surprises. From the Printer's Ink newsletter published by Thomas Shore Incorporated. So case study 18, Fred. Fred was sure he had captured lightning in a bottle. He had developed a complicated electronic apparatus that cleaned recycled glass without the need for water. Bottlers would beat a path to his door. All Fred needed to do was patent the apparatus and he would be set. Through a friend's cousin's uncle's hairdresser, he learned of a draftsman named Pinky who would prepare the patent application. When Fred met Pinky, he was told that as a draftsman, Pinky would have to be listed as a co-inventor. Fred assumed this was so and the patent was filed. The electronic bottle cleaner was a major industrial success. The bottlers beat a path to Pinky's door, leaving Fred to only partially benefit from his creative work. Fred was livid. Key points. Never list anyone as co-inventor who did not actually create the invention. It is best to file patents through an attorney registered with the U.S. Patent Office. Before filing a patent, do a patent search to determine whether the idea is patentable. This will save time and money in the long run. Patents can offer tremendous benefits. Fred knew that patent laws are one of the few areas in which U.S. government actually promotes a monopoly. An owner of a valid patent may exclude all others from making, using, and selling the patented invention. Because of this, a patent is the strongest legal tool available for protecting and ultimately profiting from an invention. Fred also knew that patents have greatly increased in importance in the last 20 years. Technology has become an indispensable part of almost every industry, and companies have greatly increased their research and development efforts to protect their investment in intellectual property. Companies and individuals are filing record numbers of patents each year in order to achieve the following benefits. Profit by excluding others from making, using, or selling the invention. Income from licensing or assigning the patent to others. The right to use other protected technology without royalty fees by cross-licensing. The avoidance of costly litigation by preventing others from obtaining a patent on the same invention and using the patent against you. Professional respect and recognition. Increased marketing appeal, media exposure, and consumer and investor credibility. The avoidance of costly litigation by preventing others from obtaining a patent on the same invention and using the patent against you. There are 3 types of patents: plant, design, and utility. Plant patents are the smallest category. They are used to protect asexually reproduced plants, grafts, and cuttings. A design patent protects the non-functional aesthetic aspects of a manufactured object. Design patents are less expensive than utility patents, and they are most useful in preventing competitors from copying the appearance of a product. Utility patents are the most numerous, and they protect new machines, manufactured objects, compositions of matter, processes, and new uses of all the above. Utility patents can protect nearly everything made by man, including software and genetically engineered animals and bacteria. The term of plant and utility patents is 20 years from the date of application. So the term of plant and utility patents is 20 years from the date of application. The term of a design patent is 14 years from the date of issuance. In order to be patented, an invention must be new, useful, and not obvious. Usefulness is seldom an issue, but novelty and obviousness are often used by the patent office to disqualify an invention. The legal definitions of novelty and obviousness are complex. What is important for companies and inventors to know is that once an invention is commercially used, publicly used, offered for sale, sold, or publicly disclosed, an application must be filed within 1 year, or a patent is barred. However, there are a number of reasons why it is desirable to file an application before any of these barrings. However, there are a number of reasons why it is desirable to file an application before any of these barring events occur. The process for patenting an invention is usually started by doing a patent search. This is an organized review of issued patents and other technical references to determine whether the invention is already known or anticipated by another person. A patent search can save a great deal of time and money by helping to determine whether the invention is patentable. The search also aids in drafting the patent application. However, if an inventor is highly knowledgeable about the industry of his invention and his invention is pioneering, a patent search may not be necessary. If the results of the patent search are favorable, the next step in the patenting process is to write a patent application. There are many rules and regulations that determine the form and consent of the application, and care must be taken to draft the application so that it results in the strongest patent possible. The application describes the invention in detail with the specification and related drawings, and it contains at least one claim. Claims are the legal weapons of patents. Claims are the legal weapons of a patent, and they determine the strength of the patent rights. Once the application is finalized, it is sent to the U.S. Patent and Trademark Office, where it is examined by a patent examiner. Most applicants are rejected at least once by the examiner. The application may be amended to overcome the rejection, or it is sometimes possible to convince the patent examiner to withdraw his rejection. The examination process usually includes several written exchanges with the examiner and generally takes 1 to 2 years. When a patent is obtained, it may be licensed in whole or in part. The best licensing strategy depends on the particular circumstances. of the inventor in the industry of his or her invention. A United States patent protects an invention only within the United States. A patent must be obtained in each country in which protection is desired. There are a number of strategies for obtaining foreign patent rights. The best strategy depends on the circumstances of the inventor and the invention. In addition, as a valuable asset, patents and other intellectual property can be a target of lawsuits. This is a valuable asset. Offshore corporations and trusts can be highly effective in shielding intellectual property from frivolous, so they call it intellectual property. Offshore corporations and trusts can be highly effective in shielding intellectual property from frivolous suits. Back to the issue at hand, Fred was also aware that by even raising the issue of who the true inventor was, he could jeopardize the entire patent. To protect his interest, he was forced to leave Pinky's name on the patent. Okay, back to the issue at hand, Fred was also aware that by even raising the issue of who the true inventor was, he could jeopardize the entire patent. To protect his interest, he was forced to leave Pinky's name on the patent. However, through aggressive negotiations and after Pinky was in an accident, all patent rights were transferred to an offshore corporation, which Pinky couldn't put his finger on. Fred received worldwide royalties through a protected offshore jurisdiction. So an APT, a asset protection trust, an offshore asset protection trust. Conclusion: patents must be timely and properly filed and vigilantly defended in order to receive the full benefits of the patent laws. Offshore corporations and trusts are useful for holding intellectual property. Offshore corporations and trusts. Never list anyone as a co-inventor who did not actually participate in the invention process. Alright, that was the end of section 5, chapter 10. Protect your intellectual properties with patents.